Hello, everyone. Happy Friday. For those of you who don't know me, I'm Cindy Condi. I'm the co-chair of the New Hampshire Tech Alliance Biomed Tech Group. And on behalf of the NHTA and the Biomed Tech Cluster, I'd like to welcome you again to the second event in our COVID-19 Best Practice Roundtable series. And thank you all for participating. And hopefully we have fewer technology glitches than we did the first time. Again, it's a new platform. We're testing things out. It's getting better every time we use it. So we appreciate your patience as we work through things. It'll eventually become a great format for being able to do some of these virtual meetings. So we kicked off the series, the roundtable series, on May 8th, a few weeks back, and it was about a 1 week after the governor announced the stay-at-home 2.0 guidelines for reopening the economy. Many of you participated, so welcome back. And we did publish the key takeaways from that session about a week after the session, and this was on the best practices for returning to a safe workplace. So hopefully everybody has had access to that. If you don't, you can feel free to email me or Josh afterwards, and we'll send you the link again. But we had some great discussions, and we're able to put together a nice document with some good best practices for the industry to share. So we have some new folks today too. So welcome to the new folks who are joining just today, and welcome everybody. We have about 20 participants that are registered, and they are covering more than 10 companies in the industry. So still a small group, and that's by design. As we get into our next session, we're going to open it up to a larger audience and have more cross-industry discussion. So I'll tell you more about that in a moment. I'd like to thank the NHTA, especially Joshua Sear. Joshua has been bouncing around tables this morning, and he's also been actively involved in driving this new technology within the Alliance. Also, 4 member companies who I mentioned last time that have helped to create this series and make the event possible. That's LS&E, NovoCure, Keyspin, and especially today, Bernstein Shur, for helping with today's topic on the COVID-19 legal matters. So I see that everybody's in the virtual ballroom, and you've had some opportunity to network a bit, so that's great. As I mentioned in our first session, we are trying something new with this platform, and I'm assuming still that you are all zoomed out, and trying something new is always really interesting. So our goal today was not to have another webinar, as I said last time, but create an opportunity for rich discussion and exchange of ideas amongst peers in the industry. So today, as it relates to the COVID-19 pandemic and legal matters that may be on your mind, specifically related to the CARES Act and some HR employment law issues and considerations that might be popping up in your companies. So to that end, today's agenda is as follows. You can see it on the screen. We've already done our networking gathering. We're doing a quick intro right now. We will be having the legal matters overview in plenary session in a few moments. We'll do a group Q&A so that everybody has the benefit of hearing the questions as well as the answers. And then we'll jump into the smaller roundtable discussions where our legal experts will bounce across the tables and join you in those discussions. Our plan again is to adjourn by 12:15 today. Just so you know, the plenary session will be recorded, and we have allocated time in that for the group Q&A, just as I mentioned before, so that everybody has the benefit of the questions and the answers. Please use the chat capability to ask questions both during the plenary session so that everybody will hear them, and also when you're back at your tables. The Q&A won't stop while you're at your tables. We'll still be monitoring the chat and hopefully answering all those questions to the best of our ability. We will have 2 legal experts, and I'll introduce them in a minute, and they will be jumping to different tables. And you should also feel free, just like you did last time, to jump around to other tables, join new conversations. Even though the conversations are going to be the same in nature, you can meet new people, but you're also welcome to stay at your own table if you prefer. Each table has a facilitator from our committee, and they'll just help guide the conversation and capture some key takeaways so that we can publish those again for your benefit. Today's goal, again, is to keep the conversations going, to share, to compare notes, to gut check with what others are doing, and just help each other out across the industry. So again, I will thank you in advance for your spirit of adventure in trying the new platform, and for your patience as we work through the technical glitches that we might experience along the way. For the benefit of the newcomers, today I'd like to ask Josh to come back on screen to provide a quick tutorial, less than a minute, because some of us are getting familiar with it, but a quick tutorial on how to navigate the platform. Josh?
Great. Hey, thank you, Cindy. I think some of you have been experimenting already, so I'm going to keep it pretty short. When we're in presentation mode, which we're here, and for those of you that are watching the recording afterwards, it's only going to take a moment. We'll go straight to the presentation. But when we're in presentation mode, we're not seeing all of you. The only people we see and hear are those that are with the videos on this camera right now. You'll see in the top right-hand corner, you'll see an option for chat. And that's for just general commentary and cheering people on and so on. If you have a question, I'll ask you to click on the Q&A tab. And when you do that, you can post a question in there, and that question will be viewed by everyone. And if you view those questions, you can upvote them and make sure that they're more relevant. I'm just going to say hi as a question just to show everybody how that works. And so if you have questions during the presentation, it won't interrupt the presentation. Go ahead and ask. And then Hilary and Cindy and myself can be identifying those questions as they come along and it's appropriate, and be answering them and checking them off the list. So please feel free to use that. The questions in the chat are not showing up in the recorded message, and you can post those questions anonymously should you want to do that. Once we're done with this and we go back to the networking portion, you simply double click to jump from table to table and bounce around if you want to do that as well. And of course, if you have any questions, you can use the direct chat function and chat directly with me and ask me specific questions. And that's all I have.
All right, thank you, Josh. So if you could just jump to the second slide, Josh. And because we're not going to be coming back into a plenary session once we go back to the tables, I just wanted to just put this one slide up just to remind you of our next event that will be coming up in the COVID-19 Best Practice Roundtable Series. The event will be held, we haven't really closed in on a date, but it'll be sometime in June, more likely towards June 19th. And this topic is going to be around the virtual workplace and will virtual workplace become the new norm? And it will be a broader cross-industry discussion, and we'll cover many dimensions of this topic that I think everybody is finding very interesting and very front of mind right now. Things like, what does that mean around people, around the company culture, process, productivity, technology, space, facilities, staffing, legal, tax issues. So really, and so many more. So this is a discussion, again, will be cross-industry and one that you won't want to miss, because I think it's going to be, the virtual workplace is going to be certainly part of the future as we go forward. So with that, I'd like to now welcome and introduce our two esteemed legal expert speakers today from Bernstein Shur. Christina Ferrari will be covering the CARES Act, and Hilary Rheaume will be covering HR employment law issues. I don't see Christina any longer, so I guess I'll turn it over to you, Hilary, to start. So take it away. Thank you, Hilary.
Okay, thank you, Cindy, and thank you all for having me. I hope you can hear me. Just to let you know, Josh, I could not hear you. So I hope that everybody is able to hear me as I go through this. I am here today to talk about some of the legal issues you should be thinking about as you consider reopening and as we continue to move through the COVID-19 pandemic. Just a little bit of background about myself. I am an attorney with the Bernstein Shur law firm. I practice in both litigation as well as the labor and employment practice groups. So I have, knowledge of some of the issues you may be facing when it comes to labor and employment, and then also some of the liability that comes with that, which is what we're going to be talking about today. So I thought what I would do is I would list, kind of 5 tips to think about as you reopen to try to reduce your liability as a company. There's a number of other tips I could give you. These tips may prompt other questions. As Josh said, please feel free to put the questions in the Q&A, and I will talk with you at the tables afterwards if you have more specific questions. But these are just going to be a general overview of the tips. So the very first one is, I think it's very important for employers to make sure that they understand the leave laws that might apply to different employees. You have probably at this point heard a lot about the Families First Coronavirus Response Act, what some people refer to as the FFCRA. This is an act that was put in place because of COVID-19, and it has two different types of leaves that are applicable to employees. The first being the expanded FMLA Act, and then also the Emergency Paid Sick Leave Act. So if you are an employer who has less than 500 employees, then you really need to make sure that you are paying attention to the FFCRA. Basically, under the expanded FMLA, employees who are not able to work because a childcare facility is closed, for example, will be able to receive up to 10 weeks of leave. And then there are different categories under the expanded Sick Leave Act that if employees qualify, such as, again, having to care for a child because a childcare facility is closed, or due to COVID-19 symptoms or quarantine reasons, they would be entitled up to 80 hours of leave as well. So again, you've probably heard a lot about the FFCRA. I can go into more detail if you have questions offline, but it's really important to keep those in mind. If you have not already, you should, as an employer, make sure that the FFCRA poster, which is available on the Department of Labor website, has been sent out to all employees. Part of the law is a requirement that employers make employees aware of these leave rights. So if you have not done that yet, I highly recommend doing that as soon as possible. Through all of this, it has become very common for employers to somewhat set aside and forget about some other types of leave that may be applicable to your employees. So to just highlight these very quickly, it's important not to forget about the FMLA. So nothing has changed when it comes to the FMLA in terms of what is a condition that an employee may be able to qualify for FMLA leave, as well as the hour requirements and how long the employee must have worked for the employer. So, just to keep in mind that that is a possibility if someone doesn't qualify for the FFCRA, don't forget to look at the FMLA. And then another piece that's important is the American with Disabilities Act. We're going to talk about this a little bit later throughout some of the other tips to reduce liability, but it's very important to remember that we need to ensure that our employees who have engaged in a dialogue with the employer about a need for a reasonable accommodation, we need to make sure that employers are continuing to have those conversations and do their best to ensure that those reasonable accommodations are available. We'll talk about that a little bit later, but I just like to highlight that so we don't lose sight of that with everything going on with the COVID-19 pandemic. So the second tip is to ensure that you are following federal, state, and local reopening guidelines. In the media lately, there's been a lot of conversation about employers' fears that they could be sued by employees who come back and then get COVID-19. Retail stores who may open and then a customer says that they had COVID-19 and were exposed to it at the retail facility. So it's very important to know that if somebody were to bring a lawsuit alleging that, they would need to make sure that they would be able to link the exposure of COVID-19 back to the employer or the, for example, retail store, and be able to allege that that facility or that employer was not following the state, local, and federal guidelines. So this is why it's very important to make sure you are following. Some of those guidelines involve, the CDC. We have all seen that the CDC has issued guidance. Just this past Wednesday, they came out with a checklist of what employers should be looking at as they think about reopening or continuing to operate. So if you have not seen that yet, I highly recommend going to the CDC website. I also recommend becoming familiar with the OSHA requirements. So under OSHA, which you're probably familiar with, they have the general duty clause, which says that an employer has to protect their employees against recognized hazards in the workplace. At this point, OSHA has acknowledged that COVID-19 and exposure to that is a recognized hazard, and employers are required to take certain measures to ensure that they are protecting their employees from COVID-19 exposure. In the first few months when COVID-19 started becoming an issue in the employment settings, the majority of complaints back to OSHA about employers had to do with proper PPE and also with training on, standard that people were safe within the employment environment. So, to the extent that PPE is required in your workplace, and you can also have, training on how to protect your employees and standard operating procedures that will be in place to reduce the exposure of COVID-19, I highly recommend doing that. And finally, in terms of the second tip of following state, local, and federal reopening guidelines, I recommend becoming very familiar with the state of New Hampshire's universal guidelines and then the guidelines that apply to your industry. And it's my understanding that those guidelines would be manufacturing. So those are all on the New Hampshire website through the governor's office. I can go through some of those in a little bit more detail when we're sitting at the tables, but the important things to keep in mind is that you need to make sure that you have a screening process in place before any employee steps on the work site every single day. So what that looks like is you need to make sure that you're asking the questions in the universal guidance, having one designated employee who greets the other employees when they enter the office or the work site, and they're asking these questions to every employee. I believe there's about 5 questions that they need to ask. You also need to make sure that employees are either having a temperature check when they enter the site or the office, or they can self-certify that they do not have a temperature higher than 100 degrees. There has been some guidance suggesting that 100.4 is the temperature that somebody needs to be under, but the governor has said 100 degrees. So just keep that in mind as some protocols you need to put in place if you haven't already. And then I highly recommend revisiting your employee handbook or any other policies that you may have to ensure that you have an illness policy. A lot of employers are right now updating their sick leave policies along with any other kind of policies that might come into play. So just make sure that you look at that. And if you are not familiar with it or you don't have one, I recommend, seeking advice of counsel to make sure you have one of those in place because they are required under the governor's executive orders. So my third tip is to, and this is a tip all the time, not just during the pandemic, is to avoid wage and hour claims to the extent that you can. We anticipate that we are going to see an increase in the wage and hour claims that will be filed, and we have already seen a bit of an uptick. A lot of employees who have had to work remotely are going and have been claiming that they have been working a certain amount of hours and no case. And for every hour earned or every hour that you work, you earn income. So we as employers need to make sure that we're paying employees for the work that they do. When people are remote, it can be somewhat difficult to track that. So that can lead to a wage and hour violation or potential wage claim. Also important to keep in mind, overtime, minimum wage, all of those laws still apply. The Department of Labor recently came out with a fluctuating arrangement that can be applied for non-exempt employees. So individuals who don't naturally fall into the exempt status. Non-exempt employees can receive a salary and then receive half of the overtime amount if they go over 40 hours a week, but only if their work weeks are naturally fluctuating. So in terms of the hours that they work every week, as long as that fluctuates, you can now use this new arrangement called the fluctuating work week arrangement. That's just kind of a side that doesn't really have much to do with COVID-19 pandemic, other than a lot of employers are starting to use that arrangement now because it is providing more flexible structures in people's work schedules. Also to keep in mind when it comes to wage and hour, just remember that if you have employees who are furloughed, they cannot perform work without being compensated. We have been seeing a lot of employees who have been furloughed and then they're asked to get on a call with their employer to talk through reopening. Well, that's time worked. That's time that they need to be paid for. And if they're not paid for that, that could turn into a wage claim. So just keeping all of those issues in mind as we move through this pandemic. None of those laws have changed, and they all still apply, and employees have the rights to sue employers for those violations. My final 2 tips, and I'll go quickly here because I know I'm running out of time, is do not discriminate and do not retaliate. So the discrimination and retaliation laws are still in effect. When it comes to discrimination, there's a lot of conversation about who qualifies for the at-risk group for COVID-19. That has led to a lot of age discrimination issues. So if people are being furloughed who fall into the older age group category, and individuals who are in the younger age group category are not being furloughed, although the employer may have had the best intent there in trying to minimize exposure for individuals in the older age group, that could still be perceived as age discrimination. So you just want to make sure that the decisions that you're making and the measures that you're taking as you reopen do not expose the company to any sort of discrimination claim. And then finally, with retaliation, the amount of whistleblower claims, wrongful termination claims, and retaliation claims are going to skyrocket. The employees who have indicated to a supervisor or their employer that there is an issue with the safety guidelines at their facilities, or they have a concern about the PPE that they've been provided, all of those issues are concerns related to safety in the workplace. So you need to make sure that you're listening to employees who raise those concerns, address those concerns, and do not terminate or discipline an employee simply based on those concerns. If an employee raises those concerns and then has a completely independent reason for being, disciplined or terminated, that's fine, but you want to make sure you're not linking the two. So I think my time is done. Those are my top 5 tips. Happy to talk with you all after we're done here.
All right. Thank you, Hilary. Really appreciate it. That was quite a bit of information, very valuable. Tried to take some good notes here. So thank you for sharing that. I'll turn it over to Christina at this point. And Christina will be covering the CARES Act. Christina?
Hi, everyone. Hopefully you can hear me.
Yes, I can.
So 5 things to think about with the CARES Act that are unique to life sciences companies. The first is that the national stockpile is something that our federal government is paying attention to. Sorry, I'm having a lot of feedback. Are you guys also hearing that? No. Okay, I'm going to keep talking. So if you are manufacturing personal protective equipment, any other ancillary medical supplies, vaccines, other biological products, you may be able to take advantage of this provision and be able to be part of the national stockpile. That's additional orders and additional supply issues to be aware of. The second unique aspect of the CARES Act for life sciences companies is that there is a limited liability protection for you if you are manufacturing PPE. This is a very broad limited liability protection. The limited is a misnomer. So if you are manufacturing PPE or anything ancillary, you will have pretty big protection against lawsuits in federal and state courts that are related to either manufacturing or selling or anything else related to those products. That's something new. So if you have questions about that, please let me know and we can get into specifics about what that means for your business in particular. The third thing is there's priority regulatory review for certain products. PPE is one, ventilators is another. There's a list of products that you can get in and out of the FDA in an expedited manner. So I've already seen this in a few issues with clients. And if you have a product in the pipeline and you don't yet have FDA approval and it may qualify, this is something to be aware of because you can get in and out with less regulatory overview than you normally would. The third thing is if you are manufacturing certain drugs or certain devices, you need to have in place a secondary redundancy risk management program. This is in light of the expedited regulatory review. So if you don't yet have a redundancy program in place, this is something that you should get in place sooner rather than later. It's a new reporting requirement and is something that the agencies are going to be looking for. And finally, if you are manufacturing drugs or medical devices critical to public health, and again, they have a list of what those are, we can talk offline about that. You need to make sure that you are reporting any anticipated discontinuance or shortages of those devices or drugs. There's now a new reporting requirement for those so that we aren't left short of certain things if another public emergency happens, like what we're seeing with COVID-19. So if you are manufacturing anything that is critical for public health as they define it, you need to make sure you're doing these reportings at least 6 months in advance or as soon as practical. So those are really the 5 major things under the CARES Act, Title III, that may be specific to you and your businesses that you should be aware of. And I'm happy to go in greater details. I'll be going to all the tables, and I'd be happy to go into detail with you.
Okay. Christina, thank you very much. Appreciate that. So I would like to open it up to group Q&A for a few minutes here. I don't know, Josh, it looks like we don't really have any questions posted, but if anybody has any questions, and you can either put them in the chat or preferably in the Q&A, this would be a great opportunity to ask both Christina and Hilary your question. So I'll give it a second or two to see if anybody pops in. We'll go from there. If we don't have any questions, then what we will probably do is just jump into the tables and continue the discussion. And I agree with Josh's chat here. Christina and Hilary were both way too thorough. That's why there's no questions. So thank you for that. All right, looks like there is a Q&A here. Can Christina please expand a bit on the redundancy requirements? And this is from Rheaume.
Just 1 second. I'm not sure I hear. Can you guys hear me?
Yes, we can hear you.
Okay. So the redundancy program, if you have failure systems in place for manufacturing, for certain numbers of you didn't have to report those to the FDA, depending on what you're producing. And we may have to have a separate conversation, just you and me, about the specifics. But under the CARES Act, they're requiring for the manufacturer of certain products, such as devices or medications, pharmaceuticals, if it's critical to public health, and again, they have a list, they're requiring that you put in place a second system, so redundancy fail-safe system. And that's really to address the government's concern that we're without the critical numbers of these products. So let's say you're manufacturing a pharmaceutical or a biologic critical to public health, as they define it, and your manufacturing goes down, and you don't have a secondary system to keep that from happening, they're going to be upset. And so they're putting this requirement in for certain types of businesses to protect against any failure in manufacturing that would lead to a shortage of that device or product. And we can go over exactly how to set that up and get that in place specific to your business offline, or I can jump in on your table. We can talk about specifics.
Okay.
I hope that helps answer the question.
Thank you, Christina. Yeah, you can always connect with Roy
Yes.
Afterwards as well. So there's another question here for Hilary. Is there an employee number floor for the FFCRA Act? You mentioned this applies to less than 500 people, but does that include very small companies, less, 1 or less than 10?
It's a great question. Yes, it applies 1 through 499. But the government, the Department of Labor has said that there is a potential exemption for small businesses, which would be 25 or less. You don't actually apply for the exemption. What you need to do is save all of if you feel that an exemption applies, you need to save the paperwork and the reasons that you felt as though an exemption should have applied for your company. I would be very cautious in doing this. I have already, and we're, late May, and enforcement started. The act went into effect in early April, and enforcement started after a grace period of a few days. And I've already had calls from the Department of Labor addressing issues with the FFCRA. So if you are able to honor an employee's request to go out on whether it's leave under the expanded FMLA or the Emergency Paid Sick Leave Act, I highly recommend that you do so. But there is, under the law, a specific exemption for very small companies. But again, you don't apply for that exemption. You just need to save all the paperwork so that if your company is audited by the Department of Labor, you can explain and have documentation to prove why you thought the exemption applied.
Okay, great. Thank you, Hilary. Just want to jump back into Roy's question because he had a follow-up around, do redundancy systems also apply to the supply chain for supply products?
It may. It depends on the product. They want to make sure, and this is DHHS that I'm talking about. I neglected to mention that. They want to make sure that there is some sort of plan that addresses any pain point in the manufacturing process, any place where it could fail. So depending on the chain and the specifics of the product itself, it may be required for every step in that chain.
Okay.
And again, this is new, and between all of us, I'm not sure DHHS has really figured out how practically they're going to do this or not yet.
Okay, thanks, Christina. A question here from Carlo, going back to Hilary. Can you explain the notification period to employees for a layoff or furlough and what the New Hampshire requirements are?
Yes. So it depends on how many employees you have in your company. So if you have 100 or more employees, then the Warren Act is going to come into play. And there is a specific notification requirement. I believe it's 60 days in which you need to notify employees before they can be laid off. But again, that only applies to employers that have 100 or more. That would be laying off 100 employees or more, I believe. I would need to look at that. Under New Hampshire law, the New Hampshire Employment Security does not have a specific requirement for the we call these mini Warren Acts. So some states have a separate notification period. New Hampshire does not. We follow the federal Warren Act. But if you lay off 25 or more employees within a certain amount of time, then you do need to notify New Hampshire Employment Security. I believe, at least as of a few weeks ago, New Hampshire Employment Security was waiving that requirement during the COVID-19 pandemic. But these things are changing daily. So I would refer to the New Hampshire Employment Security website for that update if you do end up having to lay off 25 or more employees.
Okay, thank you, Hilary. So one more question here from John Whalen. Regarding joining your company to the National Stockpile, this is for Christina, what is the process and is it consistent or effective? He's read many stories where companies reach out to the federal government, and I think this is also applying to the state government, but get no response.
That's a great question. So you have to go through DHHS, and quite frankly, going to a personal contact or up the chain to the top is much more effective these days because they're overwhelmed. And I think getting added to the National Stockpile list if you're not, can be very lucrative for your business. It's just a matter of getting the ear of the right person, because they're trying to field so many requests and decide who should be added and who shouldn't. That list is changing per day, is my understanding. But depending on the business and the product, a lot of it is going to depend on lobbying and how you present it to DHHS. And we can talk offline. I'm happy to help. We've been working on that issue for at least 2 clients recently. And
Okay.
I will say ventilators is very, very easy. That's a clear-cut one, but other ones are a little bit different.
Okay, thanks, Christina. So it looks like we don't have any other group questions. So I think what we'll do is we'll shift back into the table mode. I want to thank you both, Christina and Hilary, for your great guidance on these topics. We'll jump back into the tables, and we'll probably kind of rearrange the tables a little bit so that we've got good tables depending on how many people are still on.